The continuation of the impeachment trial of the Honorable Chief Justice of Renato C. Corona of the Supreme Court is hereby called to order. We shall be led in prayer by Senator Loren Legarda.
Amang makapangyarihan, kami po ay dumadalangin sa inyo na patuloy kaming basbasan ng karunungan at bukas na kaisipan upang makita ang katotohanan sa paglilitis na ito. Naway, gabayan ninyo kami sa pagkilatis sa bawat ebidensya at testigong hinaharap sa hukumang ito. Biyayaan niyo po kami ng kahinahunan at kaliwanagan ng isip upang maigawad ang wasto at patas na kapasyahan. Sa gawain naming ito, nais lamang po naming makapagpasya na hindi nagpapa-impluensya sa anumang alyansa o pagkiling. Sa pamamagitan ng pagbibigay namin ng tamang desisyon sa kaso na nasasakdal na punong mahistrado ng kataas-taasang hukuman, kami po ay umaasa na ito ay magiging daan sa pananumbalik ng tiwala ng sambayanan sa ating pamahalaan at sa mga nanunungkulan. Ito po ang aming sinasamo at dinadalangin sa inyong dakilang pangalan. Amen.
Amen. The Secretary will now please call the roll, Senators.
Honorable Senators Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revillas, Soto, Trillanes, Villar, the Senate President.
Salamat. With 19 senator judges present, the presiding officer declares the presence of a quorum.
Mr. President.
Majority Floor Leader.
Mr. President, may I ask the Sergeant-at-Arms to make the proclamation?
The Sergeant-at-Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 6, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 6, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will please call the case before the Senate sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Mr. President,
Majority Floor Leader.
may we ask the parties and or their respective counsel to enter their appearances?
Good afternoon, Your Honor. For the House of Representatives Prosecution Panel, same appearance, Your Honor.
Noted. For the prosecution, the defense.
For the defense, Your Honor, the same appearance.
Noted. For the defense,
Mr. President,
the Majority Floor Leader.
Mr. President, we are in receipt of a motion for reconsideration filed by Senator Miriam Defensor Santiago on the issuance of subpoena yesterday by the court.
May I request the Majority Floor Leader to read the motion for reconsideration?
Yes, Mr. President. She writes, Dear Mr. Senate President, this is to respectfully and humbly propose the procedure to be followed on the Defense Counsel's pending motion for reconsideration. I refer to this court's resolution yesterday, which approved the prosecution's request for subpoena to certain bank officials. At today's hearing, counsel from both panels should be allowed to argue the motion for reconsideration for not more than 1 hour for each side, unless the Senate orders otherwise. Impeachment Rules Number 5. After this debate, the Senate President could then give time for each panel to submit its written memorandum. After both memoranda have been filed, then the court could go into closed session, caucus, to resolve the pending motion. If necessary, I shall, despite ill health, attend this caucus if given advance notice of at least 3 hours. Yesterday, I watched the live telecast of the proceedings. I noticed that one senator stated that the rules allows a senator to file a motion for reconsideration. There is no such provision in our impeachment rules. Perhaps what he referred to were the Senate rules, which provides that any senator who voted with the majority may move for reconsideration within the next 2 session days, Rule 33. The only time that the impeachment rules allow the Senate rules to apply suppletorily is under Rule 6, which does not concern a motion for reconsideration filed by counsel. In any event, if it is your judgment that only a senator can file a motion for reconsideration, then I respectfully request that this letter should be considered as abundanti cautela, as a motion for reconsideration from a senator judge on the following grounds. 1. It appears that the subpoena would violate this court's own ruling that evidence shall not be allowed on ill-gotten wealth. Complaint Article 2, Paragraph 2.4, since 2.4 is the only paragraph that specifically mentions bank deposits. Any requests for subpoena concerning any bank deposits should be rejected. Number 2, it appears that the court's resolution allowing subpoena even for foreign currency deposits appears to be a direct violation of Republic Act 6426. The Supreme Court ruled in Intengan versus Court of Appeals GR number 12899620002 that this law is violated if a foreign currency deposit is examined, except only when the depositor gives written permission. This is the only exception, and it is not present in this case. Number 3, prosecution cited the 1997 case of Salvacion, 2000 case of China Banking Corporation, and 2006 case of Ejercito. It appears that all 3 cases are off tangent. I cite these grounds without prejudice to my final vote after the motion for reconsideration has been properly debated. Thank you. Sincerely yours, Miriam Defensor Santiago. I submit, Mr. President.
There being a motion for reconsideration from a member of the Senate, and given the fact that this is a gray area, which is not covered by the rules of the Senate. The rules of the Senate deals with matters involving legislation, where only a senator who voted in favor of a measure may seek for a reconsideration. It's the position of the chair, subject to the final position of the House, to hear the position of the movant, Senator Miriam Defensor Santiago, in person, so that we will be informed accordingly and make a decision. The gentleman from Iloilo, from Cavite.
May I inquire how the vote of the Honorable Santiago was recorded, Mr. President?
She was absent.
She was absent, therefore she did not cast a negative vote, or she didn't go with the majority vote.
That's correct.
I suggest, Mr. President, that we suspend and discuss this because that would not be a valid reason, especially in the case of the majority leader. If the letter is addressed to us, the Senate President and the majority leader, then we might have to take up the cudgels. But we do not want to do that now. So may I move to suspend, Mr. President?
No, I would like to say that the role that we play here is that each one of us is an individual judge. And the decision of the majority on a majority of 16 in this proceeding will render a conviction on the respondent. Nevertheless, each one of the members of the Senate is a judge. And I think that the proper thing to do without prejudging the case is for us to hear the views of a judge who is absent during the caucus so that he will be given a fair chance to express his views before us.
May we recognize Senator Drilon and then Senator Arroyo, Mr.
The
President.
gentleman from Iloilo.
Mr. President, a point of inquiry. When the Senate President ruled yesterday on the motion or petition for the issuance of the subpoena, the counsel for the defense took the floor, asked for a reconsideration. Senator Chis Escudero rightly stood up on a point of order, pointing out that under Rule 6 of the Rules of Impeachment, the ruling of the Senate President is a ruling on that will be carried out unless a member of the Senate shall ask for a formal vote to be taken thereon, in which case it shall be submitted to the Senate for decision after one contrary view is expressed. We would like to think, Mr. President, that precisely the point of Senator Escudero was that only a member of the Senate can ask, in effect, for a motion for reconsideration of the ruling of the chair. And yesterday, there was no such motion being filed. The ruling of the chair was not brought to the floor for voting. And that is why Senator Chis Escudero correctly raised a point of order. The question that we now raise is it not a fact, Mr. Senate President, that the ruling of the chair squarely falls under Rule 6, so that a member of the chamber can bring it to a vote on the floor?
Anybody who wants to
Senator Arroyo was seeking the floor, Mr. President.
the gentleman from Makati and Bicol.
It's a different matter. So, may we move to suspend the trial for a few minutes, Mr. President?
Trial suspended.
Ang trial para pag-usapan nila, magkokoko sila dito sa